Well, good morning, everyone, to our in-person attendees. Thank you so much for joining us today for our annual Shapiro Environmental Law Symposium. And to those of us joining online, growing by the moment, 30 have joined us online. Good morning, good afternoon, or good evening, depending on where you're joining us from around the world. We are delighted to have this environmental law symposium today, and I want to give you some opening remarks about what to expect and some preliminary thoughts about our schedule for today. So this year's symposium, as you see in the program, is focused on foreign investment and the environment, local communities, human rights, and dispute resolution. And this event is going to explore the intersection of environmental protection, human rights, and foreign investment within the context of arbitration between foreign investors and states. So today's event has many highlights that I'd like to summarize briefly for you before we get started with our first panel. First of all, my name is Randall Obaid. I'm the Assistant Dean for Environmental Law Studies here at GW Law. And it's my pleasure to give you a rundown of what to expect today. We have, first of all, 4 outstanding panels that you'll be hearing from, 2 in the morning, 2 in the afternoon. These panels feature leading lawyers, scholars, authors, and other experts from across the country and around the world, from many disciplines, including academia, government, non-governmental organizations, private sector, and they've all been actively engaged in various capacities at the intersection of foreign investment law, human rights, and environmental protection. We are certainly glad that we have an outstanding program for your reference throughout the day, and I encourage you to read the bios of these very impressive speakers today. They are really remarkable experts. We're thrilled to have them assembled in one place today and want to make the most of this opportunity at today's symposium to learn from their expertise. We're also excited to have 2 GW Law graduates among our panelists for you today. Amelia Gonzalez on panel 2 and Shireen Foti on panel 4 we are proud to claim as GW Law graduates. And with all of this talent and expertise assembled in one place for one day, we would be remiss if we didn't offer you opportunities to network with our experts, and we've got you covered there. So those of you who were able to arrive early enough this morning have enjoyed some continental breakfast. We're going to take a morning coffee break after our first panel, and I'll be telling you a little bit more about what that's going to involve. We are going to be relocating for the afternoon component of today's session up to the 5th floor of our law school building today. There's going to be signage to get you there. It's just a walk down the hall and up the elevator. We're going to have lunch there, and we're going to have our 2 afternoon panels there in what's called the FCC, Faculty Conference Center. And we're going to have an afternoon coffee break for more networking, and perhaps most importantly for networking, we are going to have a reception from 5:30 to 7, and hope you will be able to stay to join us for that, also in the FCC today. And you can also pat yourselves on the back for doing something good for the planet while you're attending an environmental law symposium. All of our food at today's event and for all GW environmental law programs events is vegan, so please enjoy. A few notes regarding some of the networking opportunities. So I mentioned the morning coffee break. And we are so delighted that our very own Professor Giovanna Gismondi is going to be conducting a book signing event during our morning coffee break. And that's going to be happening at around 10:15 this morning, right outside the room here in the Kelly Lounge where the coffee break will be set up. I'll be saying a bit more about how today's event is really inspired by the work of Professor Gismondi in a moment. We are also going to have, after lunch, when we go upstairs to the FCC, we are going to have our featured keynote speaker, Professor Jim Anaya from University of Colorado Law School. We're delighted to have him. I'll be giving a full introduction of his background and expertise before the keynote. We will then be transitioning to the presentation of our annual Grodsky Prize for Environmental Law Scholarship. This is awarded annually to the GW environmental law student for preparing the best paper on an environmental or energy law topic. And that presentation will also happen in the FCC after lunch, after our keynote, and before our afternoon panels begin. So we'll remain in the FCC for those final two panels, and then conveniently our reception will be held right there in the FCC starting at 5:30 today. So that leads me to some thank yous to give you a little more context of why we're here today and who we can be grateful for their efforts in getting this event to happen. First and foremost, Professor Giovanna Gismondi, as I mentioned, she's our environmental law fellow here in our GW Law Environmental Law program. And this topic for today's event is inspired by her work. She published a book at the intersection of foreign investment law, international environmental law, international human rights law as her SJD dissertation at Georgetown. And that is the book that's going to be available at the book signing today. And it was her network and her expertise in this space for today's theme, the symposium's theme, that really is primarily responsible for the outstanding group of experts we've assembled. So deeply grateful for Professor Gismondi's work and expertise in this space to make sure we have a successful event today. Certainly need to thank many times Claudia Delgado, our environmental law associate. In the environmental law program, Claudia up front here has been involved in every aspect of planning the event, and it simply would not happen without her tireless effort in all aspects of logistics, including coordinating contact with speakers and caterers and everything else that brings this event to happen today. We're also very grateful for Crowell and Mooring as the reception sponsor for today's event. Ian Laird, sitting back in the back of the room today, we're grateful for him being the connection between GW Law's environmental law program and Crowell to have the event sponsored by Crowell. And we really look forward to our continuing partnership with Crowell. A lot of our GW Law grads are proud to work for Crowell, and we hope to continue that tradition. Ian is a moderator on panel 2 today and will also be contributing to panel 3's discussion. We have co-sponsors listed on the back of the program. I feel like a flight attendant. All of these sponsors, co-sponsors, in addition to Crowell, are partners that we've worked with for years and are instrumental in getting the word out about our annual symposium and often supply speakers and other support for us. And certainly there are too many staff and volunteers to mention to thank for their effort in assembling this. But certainly Yingzi Dai is one of them. She's outside working with the registration table. She's also instrumental in putting together our program, our publicity for the event, and is a wonderful resource for our program. We have students assisting us, and we are just thrilled to have a great team effort bring this to you today. It's months in the planning every year, so it's always exciting to see it come together. And of course, we are always grateful to Professor Rob Glicksman, who's here in the audience. He will be introducing our the Grodsky Prize presentation this afternoon in the FCC, and he's always been involved and is very valuable resource in putting together our symposium and particularly the Grodsky ceremony every year. So at this time, it's my pleasure to introduce another GW Law affiliated member of our program, Amelia Burnette. And Amelia is a leading scholar and practitioner at the intersection of human rights and environment, and both at the US and domestic levels. And she is a Ph.D. candidate at the University of Strathclyde Law School. She has extensive experience in environmental litigation with the Southern Environmental Law Center. And closer to home for us, she taught our human rights and environmental protection course in spring of '24. She was a speaker at last year's Shapiro Environmental Law Symposium, focusing on climate justice and environmental justice issues. And we're delighted to have her as the moderator for our first panel today. We're certainly very grateful for her ongoing engagement in our program. So Amelia, the floor is yours, and we will get panel 1 to come up to kick things off for our event today. Thank you so much.
Okay. Sounds good. Good morning. I think our panel is fully caffeinated and ready to go at this point. So panel one is, I'm promising, so panel one is at the intersection of international environmental law and human rights and how that relates to investment arbitration. The way this is going to work is each panelist is going to address sort of a particular aspect of this issue for about 10 to 15 minutes. And then we're going to go into a discussion. First, I'll try to give them some really hard questions. No, I'm just kidding. Some questions to get the discussion going, and then we'll open up for further discussion. So first, I want to introduce them. We have Dr. Godwin Dzah on the end, who is an assistant professor with the Faculty of Law at the University of Alberta, where he teaches and researches on international environmental law and global corporations. Next, we're going to have Dr. Marcos Orellana, who is the UN Special Rapporteur on Toxics and Human Rights, and he also teaches at American University on international environmental law and other international courses. And then beside me, we have Dr. Maria Banda, who is an attorney with Gibson Dunn. And her practice areas include, let me see if I can remember them all actually, international arbitration, so that's good for this panel, transnational litigation, ESG, and public international law, and I'm sure there's more. So please, if you have questions about any of these areas, talk to these experts on the break. Okay, and with that, Godwin, I'm going to hand the floor to you.
Thanks, Amelia. Hope this works. Right. So my 10 minutes is sort of setting the scene for the others to pick up from. I'll talk about a few things relating to international environmental law, focusing largely on how the question of nature-culture divide follows a particular pattern of choice making that is either subconscious or very active choice making, which then has long-term implications for the way international environmental law is framed or the way we pursue choices when it comes to making decisions relating to protection of parts of the environment, either in decision-making relating to international investment or other conservation or preservation decisions in international law broadly. So this talk focuses on two things, largely the first being biophilia, or what is generally known by conservation biologists and also some psychologists as the love for nature. And the second part of it on biophobia, which signals an aversion or a dislike for nature. And my argument is that when you look at how these two ideas, biophilia on one side and biophobia on the other side, interact, they are part of the framework within which we make certain choices and how we structure law and lawmaking. Now, the idea of environmental protection suggests to most people that we care deeply about the environment and we want to do something to protect it. And so in making that decision to protect the environment, we often end up deciding which part of nature or which part of the environment to lend more attention to or to focus on. But these are not active choices that sometimes we're making. And this is where the psychologists point to how at the back of the human mind, there's a mental link between these environmental choices that we make by way of regulation or protection and our preferences for parts of nature. And so we've just taken three quick examples. In the first instance, so if you take, say, the original US Endangered Species Act from 72, 73, and you take the protection of bald eagles as a case in point, there was all this contest between bald eagles being initially an endangered species because they became quite emblematic of the American state itself. But as it grew to a point where they were being recovered, it also became a concern of how bald eagles were exterminating nature by killing things like goats or mountain goats. Now, that brought about some tension between the choices to make to protecting these kinds of animals. And this is how we often structure our Endangered Species Act, whether it's in the US, it's in Canada, everywhere else. You would find that there's a category of animals or plants that would say are endangered, some are almost extinct, and then from time to time, we move those animals or plants from those categories. So that is part of the way we make these kinds of choices. If you take the bison and its extermination in North America, particularly in Canada, if you reflect on how the distraction of the bison was actually because we loved to use its product, particularly the pelt that was made from bison. So you think about those two. The third instance, which is more international law, focuses on how the early 1933 London Convention on Fauna and Flora in Africa, which was largely a colonial treaty amongst the colonial powers in Africa, again started off by classifying animals, some as vermin, so they can be easily exterminated, and also how others would classify some animals as useful, and so they required our protection. If you take that analogy, you go to India, you'd see clearly that even the protection of the elephant as part of the British Raj was essentially informed by the love for the elephant as a projection of British imperial power in India. So there are all kinds of mental links within these choice making that we do. Now, where this becomes a bigger problem is where we now have to frame the question of environmental protection in a language of rights. And so clearly, again, layering our human choices or categories of human understanding and perception on environmental protection, we extend these choices that we make between biophilia and biophobia onto the plane of how these other decisions are made, including the protection of the environment. And my argument is that in recovering from this particular idea that we care about nature, that impetus which drives the decision-making for environmental protection, we need to be very aware of the fact that we are only making choices between what we humans like and what we don't like, or what we feel is necessary for our protection, or what requires our attention, and not necessarily that we are making really noble choices. My point is that the final point is that when you look at the question of environmental protection, which flows from what I call the intrinsic value of nature itself, one that is devoid from human centrality, we begin to question these frames of choice making, where the protection of certain species or parts of the environment do not necessarily rely on our human preferences for what we like and what we don't like, but rather thinking about the ecosystem itself and thinking about its integrity. And that helps to reorient that particular nature-culture divide that has informed the way we make choices with regards to the environment. And of course, this has long-term implications also for decisions that have to do with international investment. Take, for example, the construction of mega hydro electricity projects, where we have questions of relocation of persons and relocation of animals. The kinds of choices that we make, even in those particular instances, are informed again by what we think really we like or what we think is worthy of our attention for protection, and what we think that we can dispense with or destroy. So I'll pause here and I'll hand over to my next colleague. Thank you.
Thanks for Okay, so I think where this is going, just so I can start bridging the speakers, and then you can correct me in the discussion later, Godwin, if you need to. But is that the intrinsic choices between, well, of how we see nature and its relationship to culture is an issue that ends up coming up in the context of projects or investments that are happening between foreign investors and host states. So we're sort of working, if you will, from a normative perspective as we go through the panels towards a more descriptive account of what's happening in the context of investment arbitration. And so as we sort of move along, our next speaker, Marcos, will, I believe, turn to the right to a healthy environment and some other issues around environmental rights. I sound like I'm guessing. I do know what he's going to talk about. So thank you.
Thank you, Amelia. My name is Marcos Orellana. I'm the United Nations Special Rapporteur on Toxics and Human Rights. I'm really pleased to have the chance to be with you this morning back at George Washington University Law School, where I used to teach international environmental law for a good number of years. For those of you who may not be familiar with the role of special rapporteurs, these are special procedures of the UN Human Rights Council that monitor and report on the specific themes that they have been mandated to do so by the Council. But today I'm putting more of an academic hat on and wish to walk through the emergence of human rights standards in respect of environmental protection leading to the recognition of the right to a healthy environment. I put some ideas for 15 minutes, so I'll time myself. The first one is that, by way of context, we as in humanity are facing a triple planetary crisis of climate change, biodiversity loss, and toxic pollution. And it is often the case that the headlines are captured by climate change, and often for a good reason, because this is an emergency that threatens to render our planet uninhabitable for humans, not necessarily for other species. So sea level rise, the rise of mean temperatures, average temperatures, the unpredictability of rains, and so all of that has implications for food cultivation, displacement, and so forth. But it's not the only situation that humanity is facing. The loss of biodiversity is significant. We are experiencing the sixth, because scientists tell us so, the sixth mass wave of extinction. Now, this is human-induced, so it's not a natural extinction. The loss of ecosystems that provide sustenance to cultures around the world. And then toxic pollution, and this is what I deal with mostly over the last couple of years that I've been in this mandate and this role of special rapporteur. A couple of things to say about that. The impacts on individuals and communities are direct. And so people falling ill with terminal diseases, cancers of different kinds, infertility, so there's a range of reproductive rights that are in question. In the aggregate, so as cancer may be life-threatening for the individual, but in the aggregate, the loss of IQ points, so the impact of chemicals, hazardous chemicals in society, reducing our collective intelligence at a time when we need it most to overcome the problems that we're facing. As scientists also tell us, the reduction of the ability of viable sperm in male fertility to be able to continue our species moving down to zero in 2050. So these are dire predictions. They're, of course, go to the heart of some of the elements that define human nature, the ability to procreate, the ability to be aware, the ability to think, And so the last point on this are transgenerational effects. It's not just our generation, but also towards the future. So a couple of distillations on this first basket of issues. It is often said that we've entered the Anthropocene because as humanity, we are exercising decisive influence on the forces of nature that make up the environment, the global environment. As I mentioned, the climate emergency and the triple planetary crisis is threatening to make the planet uninhabitable for us. Third, this all has serious adverse effects on the effective enjoyment of human rights. And lastly, there needs to be a change in trajectory. And because of that, certain economic interests will be affected. That is foreseeable. It needs to happen if we are to remain human, if we are to remain viable as a species in this planet. It will also create new market opportunities, but certainly certain industries will need to change, and the fossil fuel industry is such one industry. Now, there are questions as which industries, which sectors, and how fast? And that's where I move to the second basket of issues. So from the greening of human rights to the right to a healthy environment. The starting point there is the emergence of the paradigm of sustainable development back in 1992 at the Rio Earth Summit. Much has been said about this, but I wish to focus on 2 points. First, the integration of things. So the environment not to be looked in isolation, but in conjunction with development processes. Now, that has meant that there has been an effort at finding ways of dialogue between a range of international legal fields as they concern the environment, including trade, human rights and the environment, certainly investment. And so that's a first point. And a second point is on the recasting of development as sustainable, as a process of societal dialogue. So based on certain fundamental tenets of human rights, informed participation, access to remedies, access to justice. Now, these concepts have permeated, have inspired a jurisprudence at the global level in cases heard under, for example, the International Covenant on Civil and Political Rights, and also at the regional level. So let me give you a couple examples on the right to a healthy environment, an early case concerning massive pollution in Nigeria, in Ogoniland, in the African continent, that pertain to claims of violations of the right to health, the right to a healthy environment of the Ogoni peoples. Now, this is individual right, but also a right of peoples. Much could be unpacked on that. The way that the African Commission on Human and People's Rights approached this was from the perspective of procedural rights, information, participation. So again, we see the influence of the Rio Declaration on Environment and Development. And so this process of informed participation as a process, as a dialogue in development. So that's a first case that highlights the importance of information and participation. I'll come to some distillations in a minute. In the European legal space, the European Court of Human Rights, again in the influence of the 1992 Earth Summit, opened the doors to environmental cases using its well-known methodologies of positive obligations, proportionality, the margin of appreciation. So these are doctrines in the context of the individual tradition, liberal tradition of the European human rights system, focus on democracy especially. So the right to private life. So pollution that reaches a certain threshold that interferes with private life can then be cognizable as a claim before the European Court of Human Rights. Again, much can be unpacked on this. Their cases have been many. Happy to take questions or reactions on this. Recently, we've seen a movement also that concerns the right to life. So this is, in a way, the epitome of civil and political rights. This is in the debate whether environment is an economic, social, cultural right, or is it a civil and political right, or is it a hybrid, or is it both, or is it none? Well, it's both, I would argue. But the European Court of Human Rights has decided a couple of very interesting and important cases concerning climate change, concerning massive toxic pollution. The case concerning climate change is a case in Switzerland that basically argued that Switzerland had not done enough to take meaningful mitigation action and not done enough on issues of adaptation. This was a claim presented, or a complaint presented by organizations of older women in the Klima Seniorinnen, and also on their own names. There's a lot that could be said on legal standing, the definition of victims. But what the court did in this instance is that it analyzed what are the differences in its jurisprudence on environment, where often it's source point, causation, affecting an individual, versus a situation of diffuse, where causation is attenuated, where the sources are multiple, where the victims or the people affected are multiple as well. All of that is taken into account. Switzerland being deemed internationally responsible for human rights infringements at the end of the day. The case involving massive exposure to hazardous pollutants in Terra dei Fuochi in Italy, a so-called Cannavacciuolo case, a couple of weeks ago. I was quite pleased that my report to the Human Rights Council on my official country visit to Italy is used by the court in various ways in that case. But legally speaking, we're dealing with a case where it's not just one individual that's affected by pollution, or one family or one community. This is a massive area, or broad area, widespread, where waste was brought from the industrialized north by the eco-mafia in Italy, dumped in the south, burned, and that has had adverse implications for the right to life, as people have died of cancers and other diseases. So those are a couple examples of trajectory, cognizant of time, but I do want to refer to similar pathways in the Americas, where cases involving indigenous peoples' rights have formed a vibrant jurisprudence from the case of Awastingni, and can recognize Professor Jim Anaya sitting in the room here, where the Inter-American Court recognized the right to property of indigenous peoples over their lands, territories, natural resources that they have traditionally used or occupied. And from there, the jurisprudence has grown. Was it last week, a decision by the court in a case involving uncontacted indigenous peoples living in isolation, voluntary isolation, sometimes referred to. In the Inter-American human rights system, two other points I wish to highlight. A 2017 advisory opinion that expands the notion of jurisdiction. What is the jurisdiction of the human rights system, in a way that understands that pollution originating in one country but affecting an individual community in another falls under the jurisdiction of the source country, and thus establishing a diagonal relationship between the affected individual and the country in which that pollution originates. So this is often termed as the extraterritorial dimension of human rights law. It also, this advisory opinion, opens the door for the justiciability of the right to a healthy environment in the system of individual petitions of the Inter-American human rights system. That door was utilized by the inhabitants of La Oroya. It's a case involving Peru. Intolerable levels of pollution, air pollution, especially PM 2.5, so the small particulate matter that enters the deep parts of the lungs, among other noxious substances. So a couple of distillations of all of this, again,
For 2 minutes.
of time. While there are regional well, differences in the regional systems, there is convergence. There's much convergence on human rights standards. There's emergence of duties, procedural, such as information and participation, but also substantive in terms of the due diligence that's required of states to deal with environmental risk. So setting up a legal framework, monitoring, compliance, issues of enforcement, and also importantly, issues of non-regression, and we can deal with that. There's also emergence of techniques in certain instances, the shift of the burden of proof. This is quite interesting as well. Okay, so in the last minute and a half, there's much that could also be said about the role of science in environmental risk. As a distillation again, in the face of environmental risk, the state is not an observer. It has duties to act and confront that risk. How it does so? Well, there's a choice of means, but it needs to act. And so in doing so, science comes as a tool to enable. Now, I've presented a report to the Human Rights Council on the right to science in the context of toxic substances, pointing out the need for alignment between scientific evidence and policy. We see a misalignment, not as a casual accident, but because it is quite profitable for certain industries to maintain a status quo of ignorance or confusion where there's a lack of adequate policy. In the last 30 seconds, let me just simply conclude by saying the following. In the last 20 years, at least, we have seen an integration between human rights and the environment. So if they were separate tracks at some point, now we see this integration in full force. One element of that is that from a human rights perspective, as we speak international law from the right to regulate to a duty to regulate. This is not only a right. And from that angle, it would be a disservice, I would pose, for international economic law to stand as an obstacle in the transition towards overcoming the triple planetary crisis. Thank you for your attention.
Thank you for that, that not whirlwind tour, but tour of rights. I think it's an important backdrop, even leading into your presentation, that it's not just a right to a healthy environment, and it also extends to nature and cultural rights, but actually a whole suite of rights that are potentially impacted by any projects or other types of investments that have environmental impacts. And certainly in the climate litigation context, the right to life is one of the most often invoked rights, just in that context. Okay, so now we're going to turn it over to you, moving along, so we have plenty of time for discussion to sort of help anchor this into the investment arbitration landscape. Thanks.
Thanks very much, Amelia, and good morning, everyone. I'm delighted to be here, and thank you, of course, to the organizers for the invitation. I think Marcos and Godwin have set us up for this idea that we're dealing with a number of specialized legal regimes. We're looking at the environment, we're looking at human rights, we're looking at investment. And these regimes, of course, do not operate in hermetic isolations. They can interact, and in that sense, they can conflict or they can be congruent. And when we talk about the environment and human rights, and I think we see that through Marcos's presentation, we generally think of congruence because compliance with one regime tends to advance the rights and the obligations under the other regime. But when we talk about investment law, the general perception is that investment law can be a hindrance to the attainment of the goals and objectives of the other regimes. And therefore, we have seen increasing calls for a major reform or even the dismantlement of the investment regime. Now, I would want to push back on that idea and say that dismantling it and doing away with investor protections could actually undermine the goals of the environmental regime in the long run for the reasons that I will explain. In particular, that modern environmental law cannot really attain its objectives without robust investor protections. Now, exactly how that investment regime should evolve and what kind of reforms may be needed to make it more transparent, sustainable, or inclusive is a question that I think will be explored in a great amount of detail in the remaining three panels. But what I will try to do in my time is first describe some of the changes that we're seeing in the global environmental regime, the new obligations that states are undertaking. Secondly, what this evolution means in practical terms for FDI flows. And then finally, I want to look a little bit more in that regime nexus between the environment and investment. So starting with the environmental regime, I just want to see I don't see the slide there, but let me just say it is vast and it is rapidly evolving. So many multilateral environmental agreements have been around for decades. But the last decade has seen significant treaty making that will have profound consequences for domestic regulations, corporate governance, and of course, investment law. What is striking is not just the number of the new treaties, but also the scope of the obligations that the states are taking upon themselves. So under the Paris Agreement, as everyone in this room will probably be aware, states have taken the obligation to keep the global temperature rise to net zero by 2050. They are, it's a bottom-up treaty. States are setting out their own obligations, and they're supposed to increase their climate ambition over time. So we see the incorporation of that non-regression principle that we heard about as a fundamental element of the Paris Treaty. And another need, for example, is to make the finance flows consistent with those objectives. Now, there's another treaty called the Global Biodiversity Framework, adopted in 2022 to halt and reverse losses in biodiversity by 2030. Again, going to this idea of the triple planetary crisis that Marcos was talking about. It contains a number of very ambitious targets, including the conservation of land, 30% of land, water, and marine areas by 2030. Also the restoration of 30% of degraded ecosystems by 2030, among many other targets and objectives. Negotiations on a new global plastics treaty are currently underway, which is aimed to end plastic pollution across its life cycle by 2040. What makes these treaties significant is the scale of regulatory reform that they would require and across different sectors and industries. They're not aimed to regulate just a particular pollutant, like CFCs, for example, or protect a particular species, like migratory birds. They are aimed at the transformation of how our economies work through decarbonization, through biodiversity protection, and eventually deplastification. So some of the features that we're seeing in these new treaties speak directly to that nexus with human rights. So the Paris Agreement, for example, which is going to turn 10 this year, specifically acknowledges human rights in its preamble. And that was a hard-won provision. When we get to the biodiversity framework adopted 9 years later, we see that it is peppered with references to both human rights and indigenous rights as a key element of its implementations. And it is supposed to follow a human rights-based approach in its implementation. So in this sense, these treaties are going to be extremely invasive in terms of how domestic regulations evolve. And of course, alongside this treaty-making moment, we're also seeing the evolution of international jurisprudence. International courts and tribunals are considering climate change in 3 different forms right now. The International Tribunal for the Law of the Sea issued a major decision on climate change in the maritime context of UNCLOS last year. And currently, both the International Court of Justice and the Inter-American Court on Human Rights are considering climate change and state obligations stemming out of this. So this evolution of legal obligations under the new treaties, the evolution of international jurisprudence in these areas can feed back into how states understand and implement their domestic obligations, how investments are promoted and received, and how international tribunals decide these cases. So turning to the next point, what does this have to do with the investment regime? Well, as an initial matter, the need for investment in climate mitigation, adaptation, and biodiversity that is envisaged under these treaties is substantial. Each one of these treaties carries an enormous price tag. If we look at climate mitigation alone, the IMF estimates that the investment needed to reach net zero targets by 2050 is $5 trillion annually by 2030. When we think about the energy transition that is contemplated here, we're looking at everything from renewable energy to energy efficiency, electrification, infrastructure upgrades, sustainable agriculture. Hundreds of millions of people who are living without electricity are probably seeing renewable energy as the best chance of bridging the energy gap while keeping the temperature rise below 1.5 degrees Celsius. The cost of adaptation is additional, between $300 and $400 billion a year. The Global Biodiversity Framework then estimates that the finance gap for the implementation of the treaty's objectives is $700 billion a year between now and 2030. Things such as nature-based solutions, which could include afforestation to restore degraded landscapes, regenerative agriculture, and sustainable infrastructure are massively expensive. Some of this investment will flow from the public finance, multinational development banks, and treaty organizations like the GEF, but much of it will have to come from the private sector. Again, according to the IMF, the private sector will need to cover between 80 to 90% of the required investment for climate mitigation in emerging markets and developing economies by 2030. And it is recognized that part of the difficulty in compliance here is that some of these countries face significant challenges in attracting private capital. So how do we get around that? And how do we redirect some of those sustainable investment flows to where it needs to go in support of the global environmental treaties? Part of the solution, as UNCTAD has argued, is that investment treaties will need to play a key role in supporting FDI. Alone, they cannot do the job, but they are an important element of a state's overall institutional and macroeconomic setup. And so from that perspective, a robust investment framework that protects private property rights and is aligned with the global environmental framework is basically an example of regime congruence. However, and this leads me to the final part, there is a growing perception that the investment regime could be a hindrance to the implementation of the Paris Agreement and the global MEAs. As many of you will be familiar, in a 2022 report, the UN Intergovernmental Panel on Climate Change noted the potential for investment agreements to increase low carbon investment, but it also underscored the concern that it may lead to regulatory chill and impede the required mitigation measures. And this view has increasingly been echoed over the last 10 years by other organizations like UNCTAD, which has proposed its own reform package for investment law, the OECD, which has also embarked on this analysis. The Special Rapporteur on the Environment and Human Rights has basically called for states to urgently end their exposure to the ISDS system, Inter-Investor State Dispute Settlement. And a number of states themselves, like Brazil, have highlighted the constraints resulting from this system and have opted out of ISDS in their investment treaties. Part of the concern is that since the proliferation of investment treaties in the 1990s, there has been an undue restrictions on the state's regulatory space, and that these old treaties are simply not alive to the concerns contained in these other regimes that we're examining here. While investment treaties contain investor protections, and often give states access to remedies, they're generally silent about these other regimes. And the tribunal's jurisdiction to consider the other regimes is narrow. They're agnostic about the nature of the investment, so they will protect investors and investments equally, regardless of the sector and economy, and they tend to be indifferent about their ultimate social or environmental impacts. So many commentators believe that this is not good enough. So what does the current regime nexus look like? Well, the landscape is extremely varied, often driven by the facts of the case, but I just thought I would mention a few high-level data points. So according to UNCTAD, about 15% of all known cases, and they number over 1,000 at this point, relate to environmental protection. So these regimes are interacting because the claim will arise out of environmental measures such as cancellation of a license or environmental and social impact assessments and the like. Secondly, there is a significant number of cases that are brought by fossil fuel investors specifically, approximately 20% of all cases. Now, to be clear, not all of these disputes relate to climate or environmental measures, and not all of them are successful, but they have fed into concerns and calls for reform. And then finally, renewable energy investors also are frequent claimants. In recent years, there have been over 100 such cases, usually arising out of regulatory changes, such as change to the incentive regime for renewable energy. These numbers are not surprising. Energy extractives, infrastructure, these are exactly the kind of cases that are most capital intensive, that have a long lifespan, and that are likely to see regulatory change over the project's lifetime. But these are exactly the kind of cases that are at the heart of the concern about regime interaction. Many of them have been brought under these old generation treaties, and I think we'll be hearing a lot about old and new generation in the rest of the day. And those treaties, as we know, are silent and agnostic about regime interaction. But that doesn't necessarily mean that tribunals will not consider the norms arising from the other regimes. A number of cases have considered the principle of systemic integration. In a recent case, for example, Urbacer v. Argentina, the tribunal ruled that under the principles of international law and the Vienna Convention, the tribunal is entitled to consider international human rights law. That was in a case involving counterclaims brought by the state. And then in a recent case, actually, the one that Marcos also mentioned, La Oroya v. Peru, the tribunal asked to be briefed on what weight, if any, it should lend to the ruling of the Inter-American Court on Human Rights. Now, this case is unusual because it involves two parallel proceedings involving the same investment, but I think it does highlight the potential for congruence or conflict at the intersection of these regimes. And it is possible that as the international environmental law regime evolves, as human rights evolve, we are going to see more of these principles trickle into investment cases. The Paris principle of non-regression, for example, and when we think about legitimate expectations, or the duty to prevent transboundary harm or procedural rights and due diligence. Now, looking briefly at new generation treaties and reform proposals, the big change here is that there is a general trend towards the recognition of the regime nexus. So the general trend has been to carve out a greater space for regulatory freedom generally, and with respect to human rights and the environment specifically. There are a number of examples, and we can talk about them more if there is interest in the audience. Model treaties adopted by Canada, by Netherlands, a number of FDAs, EU-Mercosur negotiations. They have specific references to other rights and obligations, including specifically under the Paris Agreement. Obviously, it remains to be seen how they operate in practice and how they're interpreted by the tribunals. The view within UNCTAD is that they don't go far enough and that greater reform is needed, including to distinguish between sustainable investments and high carbon investments, for example. Now, in conclusion, to summarize, the fundamental objectives of these new treaties that we are seeing being discussed, plastics, chemicals, biodiversity, cannot be achieved unless investment can continue to flow where it is needed the most. Doing so will require a robust investment regime that includes the protection of investor rights, and efforts to disband this regime are likely to prove counterproductive. So there is potential for inter-regime harmony and mutual benefits, including potentially through systemic integration of international law. But to achieve that regime congruence, the reform efforts will need to continue to balance both investor protections on the one hand and the objectives of these other regimes on the other. Thank you.
Okay, so I will pose some questions to our panelists, and then I will turn it over to you guys to pose some additional questions. But a lot of ground has been covered, so we have to decide exactly where to dive into this landscape, where you can definitely see the development of human rights, and particularly in some of the traditional environmental litigation fora, human rights courts, domestic courts, and then you also see the similar types of disputes or similar fact patterns ending up in the context of investment arbitration, because those same fact patterns result in situations where maybe third parties to those proceedings might be saying our human rights have been, implicated by this project in one way or another, or where states are asserting their right to regulate based on protecting or duties to protect those human rights. So coming back to a couple of points. One, let's start with Godwin. When we're thinking about expanding understandings, I guess, of nature and cultural rights, and thinking through to how to meaningfully engage what I'll call investment-affected communities. So communities where the hydropower project is occurring, or if we want to, connect in with decarbonization and just transitions that are occurring, other types of even renewable energy projects. How do you see this being sensitive to and aware of how we shape and think about the nexus of nature and cultural rights? How do you see that, or do you see it related to meaningfully engaging these communities that are essentially going to be receiving the foreign investment projects, hosting?
Thank you, Amelia. So maybe let me start on a very provocative note by saying that it always seems that the starting point would have to always be rights. And perhaps that's always the framework within which the question of nature and culture sort of lose that connection, because then we are trying to appeal to things that are what I call the legible registers of our human understanding of that connection. So one, international foreign investments quite often would make choices between what is useful and what could be improved. Improved meaning what could be subject to human use or economic development or growth, however described, and what essentially we can do away with. So there's that choice making between what is useful to the investment process itself and whether it is characterized as sustainable or not. These are all patterned along human choice making. Now, where this becomes quite problematic is that because these decisions often follow the biophobia, biophilia axis that I was alluding to in my earlier remarks, it means that it's almost impossible for even indigenous peoples to present their connections to the intrinsic value of nature without having to find the language and the categories of rights as the mode of expression. So within that particular framework, there's already a flawed premise that it has to be processed through rights. And rights, actually, I mean, if you wanted to take even the Hofeldian analysis of right, you put rights here, you put duties here, you put power, you put disability, if you want to go through all that category. What it signals is that there has to be some choice making. But essentially, indigenous people, when you listen to them and you engage with them in their cultural spaces of understanding and ways of knowing, they are not making those kinds of, for want of a better expression, Eurocentric choice making that rights language imposes on the framing of their issues. So that's the starting point. And so if you take, for example, either the World Bank or the IMF's own ways of ensuring environmental and social safeguards, they all are framed around rights. So indigenous people are consistently being pushed into the space of making those kinds of choices when, in fact, for them, culture is integrative of nature and vice versa. What we do through the registers of rights is to signal to them that they need to be making certain kinds of choices as to what is useful or not, so that development can follow. And then we then call that social license, whatever, or any of the other attributes that we sort of plaster over their concerns. And increasingly, we see the return of indigenous people to either the African Court or the Inter-American Commission, the African Commission. All of these are avenues that they need to express their problems and their concerns through these registers of rights. That's why I started off by saying, let me start off on a provocative note. So I think that there's something useful with rights, but I think that rights in itself, in the way we frame the responses that indigenous people are seeking, is already flawed in the way that it engages with how this so-called biophilia and biophobia axis operates in interacting with investment.
Okay, so then is it fair, I'm going to lead the witness. Joking. So that I understand, it sounds like if we're bridging into the investment regime space, one of the challenges you're bringing forward is rethinking how we have this, sort of inclination to compartmentalize how communities are advocating sort of for their existence, essentially. And I could see conceptually how that could connect to, for example, the state's right to regulate, the state's space to regulate, which then could open up, does that space, and those public policy concerns, can they be shifted beyond the horizon or to account for a horizon that is not just in a rights framework, which may not be capturing really traditional indigenous knowledge, ways of life, and that nexus and connection of culture and heritage? I'm going to put that question to you, but also to Marcos, in terms of changes or because you brought it up when you were speaking about states and their role in the right to regulate and how that manifests in the context of investment arbitration. So you can, respond to me if you want, Godwin, and then also Marcos. I would like your thoughts.
As we see, just my 2 fingers on this small point. So first of all, I think that, again, when you talked about the question of the right of the state to regulate, for example, it also emanates from the initial right of the state to exercise sovereignty. So let's just walk back a bit of history and see how, for example, a lot of African states use drawing their strength from the process of political decolonization, extended that language largely on, for example, in the context of permanent sovereignty over natural resources, where they exercise a greater control in the so-called post-colonial period over their resources. But that became another avenue for, again, the post-colonial state itself. That's a critique of the post-colonial state, to assume a greater control over the resources only by replacing the colonial structure. Take away the colonial master, but the post-colonial elite become the new colonial masters. And they use that language effectively as a way to dispossess and to literally oppress their own peoples. And we see that even in very recent times, where a lot of African countries have largely rejected even the categorization of African peoples as indigenous peoples, only so they can use that as a category to deny them, again, back to rights, deny them the kinds of spaces that they can use their agency to challenge the state, that is the post-colonial state. So something that I call weaponizing sovereignty. So the state, post-colonial state, weaponize sovereignty and then weaponize the right to regulate as a way of dispossessing indigenous peoples by either labeling them as not indigenous because that dispossesses them from the capacity to stand up and use their agency. And then two, allows the state to continue the same old patterns of resource extraction without any particular resistance from indigenous people. So there is something to be said about how the right to regulate itself throws us back to the right to sovereignty, which then became a tool for oppression in very many clever ways, especially even if you look at post-colonial states engage with the idea of the right to regulate.
And then I think you also want to chime in. Okay.
Well, I'm happy to offer a counterpoint. I largely agree with you, Godwin, on many of your points at the aggregate level, at the big picture. And if I could mirror some of the things you said, there have been quite deep critiques of international law and international human rights law, including because they force indigenous peoples to think or frame their claims in a certain way. And this has been tied to the colonial origins of public international law. And so the extension of some concepts like you articulated of permanent sovereignty over natural resources as another doctrine of dispossession in effect. So, but where I would differ, I would say is that if we look more in the granular scheme of things, if we look back in time, a few decades ago, this debate that you're putting on the table manifested itself, I would say, with great force in regards to the rights of minorities and cultural rights under the terms of the International Covenant on Civil and Political Rights. But more recently, with the expansion of the range of rights that are implicated in indigenous people's claims, that concern seems to me to have waned to a large degree, at least been moderated. Let me give you a couple examples. In my role as UN Special Rapporteur, 2 years ago, I presented to the UN General Assembly a report on indigenous peoples and toxics. That was the result of extensive consultations worldwide with indigenous people in partnership with the indigenous movement. It involved collaboration with the Special Rapporteur on Indigenous Peoples' Rights, with the UN Forum on Indigenous Peoples' Issues, and other spaces. And in that discussion, the right to a healthy environment was articulated by indigenous peoples themselves, not as an imposition, but as a claim. And sure, we can again go back to the big picture notion that peoples are being forced to speak a language that has been developed in a vocabulary that has been developed elsewhere and doesn't necessarily reflect the cosmovisions and cultural traditions. And at the same time, there has been an evolution of international human rights law to accommodate cultural diversity and the various viewpoints that are relevant to understanding what is the interaction between humans and the natural environment in various settings. And so in this report that I mentioned, and in my continuous engagement with indigenous peoples around the world, what often comes about is, we have a right to live, and that seems to be universal. We have a right to our lands, and we have to right to decide. And it's often the case that the claims are, well, this company came here, it didn't ask our permission. Now that could be framed in legal terms of free and prior informed consent or a right to property in other ways, but it does come down to certain, at that more granular level, of notions that are shared, I would say, and that international human rights law is able to channel in that language, especially as it concerns the right to a healthy environment.
Well, just to add in, when we talk about rights, there's also a question of whose rights we're talking about. And I think in this setting, the discussion has primarily been a right to a healthy environment as an extension of human rights. But increasingly what we're seeing in a number of domestic settings and tribunals are basically also recognizing the right of the environment per se, without the need for that environment to be connected to the standing or the rights of any particular humans. We saw that in domestic decisions of the courts in Colombia, in New Zealand, and the Inter-American Court itself in its landmark decision on human rights and the environment recognized that autonomous right of the environment to protection, which could potentially open the door to a number of other decisions domestically, internationally. The idea being that legal standing could potentially be and is being expanded in a lot of these settings. And again, that can feed back into the investment regime to the extent that domestic law is being implicated through regulations or as being a part of the source of the law that the tribunal is considering. So this is maybe the next frontier that we might be encountering when we look at investment cases.
Okay, so are there questions in the audience? Okay.
Good morning, everyone. My name is Dzah. I teach international energy law at the University of London, and I'm visiting Georgetown this semester. So very happy to be here today at George Washington. So I have a number of points that I wanted to raise, but perhaps I only registered in the interest of giving others to ask questions. I have questions for you, Maria. I want to challenge a bit 2 points you made in the interest of generating discussion. So the first is that you mentioned Brazil, and Brazil is not a signatory to any bilateral investment treaty, and yet it welcomes a lot of foreign investment. Now, it could be down to the fact that Brazil attracts investment because it's a very, significant state in the region. It's a large state with a relatively strong economy, despite, the last years having suffered a bit. And my point is, do we really need as such investment treaty? We see also in Europe at the moment, a lot of states, in fact, the European Union, in addition to other states, withdrawing from the energy charter treaty because they feel that is not aligned enough with the Paris Agreement, and the effort of modernization wasn't ambitious enough. So in countries where domestic courts can offer to foreign investors the application of the rule of law, I don't know if we need investment treaties, because to some extent the argument is we need investment treaties when we need to outsource to an arbitral tribunal decision. And it's not even true that arbitral tribunals take less than domestic courts. They can take very long. So that's my first question. Do we really need investment? The second is, if we do, then does the problem lie with investment treaties per se, or with states sometimes signing investment contracts and maybe asking a foreign company to do the wrong thing? For example, authorizing a foreign company to mine on a sacred site. I mean, no one requires that state to do that, whether or not the investment treaty is there. Why do they do that, right? It's not the purpose of investment treaties to protect the environment, to protect human rights. That's not the objective of investment treaties, right? And in fact, this regulatory space we're talking about, the right to regulate and the protection of the environment and the protection of human rights, emerged in later generation investment treaties in the form of exception, in the form of carve-out. But a state can actually decide what investments to grab. And then if the state does the right thing, then perhaps the issue lies with the tribunals are interpreting the investment treaty in such a broad way as to, sort of derail the whole system. And that's where the whole conversation on ISDS, I think, has come up, because states feel that they need now, to retain control. So
I'm going to let her go ahead and answer this question. Thank you.
All great questions, and I think we can probably spend an hour discussing them. So I might just take a little sliver of that.
Our panel is just going to stay here all day.
So let me just start with the first question, kind of the overarching point, do we need them or not? So I've certainly seen arguments commonly made in the literature that investment treaties are not needed because investments do flow. What I would question when, we look at those meta-analysis is whether investments were supported, for example, by domestic investment statutes, which effectively provide the same kind of protections, sometimes with less transparency, or additionally, if there were concession agreements, because there are many ways that investors can obtain protections. And those other forms of investor protections are often less transparent and less subject to international scrutiny than investment treaties that are negotiated by two contracting states. So according to the more recent analysis, it does look that investment agreements do help attract FDI. But importantly to emphasize, standing alone without additional factors such as macroeconomic conditions, credit rating, stability, and so on, they are not sufficient, or good policies basically to support them. Brazil is interesting because obviously it is a big economy that can stand on its own, and investors have been flocking to it. But Brazil has its own model investment treaty, on which some other countries have also based their new model investment treaties, like India. And the difference with Brazil, which has now concluded investment treaties, is that it doesn't include ISDS. And Brazil has taken the position that for its circumstances, it does not like or need ISDS. It prefers to negotiate on a state-to-state level. So there's probably no size fit all. Different countries will have different interests, capital importing, capital exporting, how they're situated, whether they're regional hegemons or not. So I think what you see in the UNCITRAL discussions right now, which are examining all of this, there is a variety of perspectives being offered depending on where one sits. But I would say that the alignment, it would be helpful if the alignment of regime starts at the top level, at the level of contracting sovereign states, as opposed to being allowed to the discretion of various tribunals, many of which will, for example, not have the expertise in these additional regimes to actually opine on them, because I think we have to be a little bit careful what we wish for. If a tribunal that has no experience in the environment or human rights is now asked to opine, for example, on the implementation of another treaty. So I'll just leave it at that, and we can carry on.
Okay, looks like we have time for one short question. If they're really short, maybe two, but that might be ambitious.
Yeah, thank you for the presentation. For the panelists, my name is Byron. I'm a candidate here at GW in the International Comparative Program. And my question was to Dr. Marcos. There are currently advisory opinion pending for the ICJ and, the Inter-American Court of Human Rights and the African Court of Human Rights as well. So there are requests basically on the states defining the scope of the state's obligation on human rights. So what do you think are few of the suggestions which you think that these advisory opinions should, say about the climate change concerns and human rights obligation defining the scope of the states?
Thank you very much for your question. It's a big question. The scope of jurisdiction is different in the various bodies that are hearing these requests for advisory opinions. Let me make a couple of points. One, in regards to the Inter-American human rights system, I think there's a big issue in terms of how climate change can be framed as a public interest issue concerning the Latin American Caribbean region, so the juridical space over which the Inter-American human rights system exercises influence and authority. And that then concerns in the more granular range of issues. So legal standing, so we can expect pronouncements on that, clarification of what are the obligations of states, both in respect of mitigation and adaptation. Perhaps here a parenthesis, Godwin, you were mentioning earlier about benefit sharing as well. And there we see a progression in human rights law that has articulated this as a safeguard and as a duty of states whenever there is a development project or an investment project, especially in indigenous peoples' lands, but also on tribal peoples and others. I mentioned that because there are international environmental instruments that concern benefit sharing in respect of genetic resources that don't necessarily go far enough in comparison with the standards elaborated by the Inter-American Court of Human Rights. And so the point here is that we have the Paris Agreement, as Maria mentioned. It's largely a voluntary, it's a treaty, but it's largely a voluntary instrument, sure, due to progression, highest levels of ambition, but nationally determined and no mechanism really for accountability. And so the point is whether that I'm making now is whether the court will feel that it is bound by that as a ceiling, as it were, or is that a floor and it will go further in terms of its articulation of mitigation requirements. I think that that is on the table very much at this time. In respect of the ICJ, Maria, you mentioned the International Tribunal for the Law of the Sea, so the notion of a due diligence and the ICJ, this will be an element of as well. I think a big part will be also whether the right to a healthy environment has attained the status of international customary law, or it has not, or is an emerging norm, or it or not. Those many of the islands that have intervened, most, all perhaps, have argued in this direction. Some Western states have argued in the opposite direction, the United States and some Western European countries, not to mention Saudi Arabia. So that is a big one as well. So those are a couple observations of what we can expect from those decisions. But at the end of the day, it's what you make of those decisions. And so the impetus for catalyzing action at the national level. And here, I think I'm going back to your point, Godwin, about the right to regulate an expression of sovereignty. So I was mentioning from the right to regulate to the human rights duty to regulate, but to regulate adequately, because otherwise we have laws that have been challenged because they enable the kinds of dispossession, human rights infringements, pollution that are reminiscent of colonial times. And so a human rights-based approach puts a strong challenge into the business as usual of environmental regulation. And so that maybe the organizers of the conference could think about what a human rights-based approach to environmental regulation could be for next year's symposium. Thank you.
Okay, I think we are at the end. Well, we are past the end of our time slightly. Thanks again to our panelists. I thought it was a really interesting discussion, and please grab them unless they're really trying to get coffee quickly, but and ask your additional questions of them. I think what we can see from the presentation is that this is a really active legal landscape right now, in that both the shape of rights, like a right to a healthy environment, the content of that right, the scope of rights is itself taking shape right now with the global crises that we're facing that Marcos talked about. And in addition, the investment regime is also undergoing some changes and transformation sort of against that backdrop. And that includes reform proposals that we didn't talk about. Maybe later panels are going to talk about them, but there are reform proposals in that context that aim at least, or designed at least, to be responsive to these concerns. So please keep talking to us after the panel. Thank you.